The wheels of justice grind slowly as a North County man tries to get his name cleared in a 14-year-old murder case involving his sister. And a bill to stop employers from using want ads seeking people who already have jobs is making its way through the California legislature. Are the ads discriminatory? Attorney Dan Eaton is here to talk about some of the legal questions these stories raise. Dan, it's so good to see you.
Nice to see you, Dwayne.
Let's start with the Michael Crowe case, the story out of Escondido. His lawyer is asking a court to declare him factually innocent in the murder of his sister. Hasn't he already been declared innocent in this case?
Well, not quite. The charges were dismissed, Dwayne, but he hasn't actually been declared factually innocent. So what his lawyer is doing is using a provision of California law that allows you to seek a declaration of factual innocence. What does that mean? It means he's seeking a declaration that Mr. Crowe never should have been brought into the criminal justice in the first place in connection with this crime he did not commit.
And so what is he actually asking the judge to do next week?
What he is actually asking the judge to do is to, after evidence is presented, to declare him factually innocent and order state and local agencies in connection with any records that may exist about his connection with this crime destroyed, sealed, and then eventually destroyed. Why is that important? Because these records still exist, even though the charges were ultimately dismissed, and they can show up in a background investigation, for example, for a job. So this is a very important step that he is taking, and it'll be very interesting to see if he can establish the very tough burden necessary to get this factual showing of innocence.
Something like this could happen to anyone.
It could happen to anyone, that's right. And that's why, in particular, in a case like this, where he clearly did not commit the crime, he is seeking to have his name completely cleared in connection with this crime.
Now, someone else was found guilty of murdering Michael's sister, Stephanie, Richard Tewitt. So what is the status of his case?
Well, actually, he was convicted, and then it was reversed on. Ultimately, the Federal Court of Appeals decided that there were some problems with the conviction. So now that case is still very much pending. But the issue with respect to Mr. Crowe still remains. That is, he had nothing to do with the murder of his sister, and therefore he is seeking an affirmative declaration that he is factually innocent, that there was no reasonable cause to bring him into this case in the first place.
Well, the other story this week that raises some legal questions has to do with want ads, specifically asking for people who are working to apply and about asking for current employment information on job applications?
Well, you can certainly ask for current employment discrimination. What this particular measure, which was introduced by Michael Allen out of Sonoma County, would do is it would prohibit employers and employment agencies from screening out the unemployed, from using ads like "the unemployed need not apply." And the reason for that, says Mr. Allen in a video that's actually posted on the Assembly's website, is because, look, we're looking at 2 million unemployed Californians, and it's simply not fair for them not to at least have a shot at explaining why they are unemployed at this time or were in the past.
And from a legal standpoint, is this discrimination?
Well, of course, any time you differentiate between candidates based on any criteria, lawful or unlawful, you are in a sense discriminating. The question is whether this ought to be an unlawful form of discrimination. For example, it's illegal to discriminate on the basis of gender or race and so on. Now, this particular bill wouldn't quite raise it to that level for a variety of reasons that we can get into, but it would still prohibit employers and employment agencies from categorically barring the unemployed from applying or being considered for job openings.
And what does this Assembly bill say about those want ads specifically and asking employers or employers asking prospective hirees about information on applications?
It says you can't use them. The provision, if it's ultimately enacted into law, and understand it's still a proposal at this point, would say you can't use those kinds of ads. Interestingly, there's provision in the bill that says that you can say that you're only promoting from within. In other words, you can say you're restricting the process only to those who are currently employed at this particular employer. That's okay, but you can't say the unemployed as a group cannot apply. That would be considered illegal, and if you use those kinds of ads or you have that kind of a practice, you could be subjected to fines.
And quickly, we've got 10 seconds. What does this say, or what effect do you think it could have on employers?
Well, it could actually burden the hiring process, and the irony is, from the employer's standpoint, that it could make hiring more difficult and make the recovery that much slower. That's the argument against this measure.
Attorney Dan Eaton, thank you.
Thank you very much, Dwayne.